for attending our workshop on taking your game to the next level, demystifying the legal issues. So it is a legal session, so we'll try and keep it nice and interesting for you guys. So we better start a new game. So just introducing ourselves. So I'm Ed. I'm a partner at Hudson Gavin Martin. So we're a technology law firm. We act for a whole lot of technology providers and customers of technology. A lot of our customers are technology clients, and so, for example, we helped Unity purchase the assets of Weta Digital a couple of years ago. So a lot of the stuff that we're talking about here will basically be based on sort of war stories and things like that, based on what we've done in the past. Anyway, I'm not just a lawyer that just does law and stuff. I actually am a bit of a gamer. I've played, I'm probably showing my age here, but started off with an Amstrad CPC 464, Commodore 64, Nintendo 64, and then the 20-cent arcade machines at the corner dairy. And then I have owned pretty much everything except for, sorry guys if you're a Xbox fan, but I've pretty much owned all of the Sony products. And the stuff in blue I still own, and my wife hates it because I'm just hoarding stuff. But then I bought all those games, right? So I need to be able to play them. The great thing is that I have a 7 and 9-year-old daughters who love games now, and so I get to basically bring out all those old consoles. And the funny thing is, their favourite games are actually the ones on the arcade machine that we've got, which has 1,500 games. And so I like that they love the old school, pixelated games that we used to play when we were in the 80s, 90s. So that's me, and this is Calvin.
So, hey everyone, I'm Calvin. I am in the corporate team at HGM. As you can see there, really like a couple of series. And fun fact, while I did not own Smash 4 for the Wii U, I did own it on the 3DS, and let me tell you, playing a fighting game on those 3DS nubs that they had for control sticks was not a good experience. And played a lot of Monster Hunter. I'd like to think I can roll a Rathian Roar or two pretty well. These are just some of the games that I've played over my uni career especially. I mean, others including WoW, Diablo 3. That's before the Real Money Auction House was deleted. RIP. So if you know any of these games, you may be wondering how I managed to complete my degree or hold down a job. All I can really say is that probably the only games that would be more devastating to my career would probably be Dota 2, League of Legends, or EVE Online. But yeah, that's me.
Cool, thanks Calvin. So today we're just going to break the session up into two. Part one, we're going to talk about legal issues which are relating to your business, so the company that you have set up, or if you haven't set up a company, we'll talk through how you can set an entity up. And then the second part will be relating to legal issues relating to the actual development and commercialization and licensing of your game. So in terms of the first part, what we're going to go through is the different corporate structures that you could use. I'll talk a little bit about understanding what IP is, or intellectual property, because there's a different understanding of what IP is, so I'll just go through a very quick summary of that. And then finally I'll talk about, in this part, how to set up a structure to protect your IP. So I'll just hand over to, this is still me. Before I hand over to Calvin, I just thought, who actually really cares about the legal stuff, right? I'll tell you who. You should. You should, as owners of a game or any product for that matter, you need to make sure that you have your house in order, because essentially what you've got is a product where the underlying asset is intellectual property. Okay, it's the copyright, the trademarks, all that sort of stuff in your game, and you should be protecting it from day one. Because if you try to sell later on or exit or get investors on board, what they'll be looking at is what IP do you have, right? Essentially, that's what they'll be looking at, as well as a whole lot of other things. Your customers care as well. They will want to know what terms and conditions are in place, how do you protect their privacy, how do you protect their data, all that sort of stuff is important from a customer perspective. Investors, shareholders and potential purchasers, they will want to know how well your business is set up. Have you got contracts in place? Have you just generated contracts from ChatGPT or taken them from the internet somewhere and not actually had a proper read of them? Or have you got professional advisors helping you, i.e. lawyers, to do that? And then finally, the authorities really care. So here in New Zealand, we've got the Office of the Privacy Commissioner, who will be looking at privacy issues. So if you've got a game and you collect a whole lot of information, what happens if you use that information in a way that you're not supposed to use it? Or what if you have a data breach? Do you report it to the Privacy Commissioner? The Commerce Commission here, they want to know that what you're doing is fair to consumers and that there is no misleading or deceptive conduct. And so that applies across large enterprise right through to if you're a small business. So it has multiple applications. And then the Department of Internal Affairs, for example, they will care if you are running a platform that involves gambling. Because essentially gambling here is illegal unless you do it in accordance with the Gambling Act. So there are issues around things like, if you're offering loot boxes or things like that in your games, is that gambling? Can you do it? All that sort of stuff. So everyone should care. And I'm going to hand it over to Calvin.
All right. Thank you. Cool. All right. So I'll be mostly taking you through the topics which deal with company structure, shares, share issues, and stuff that your investor might negotiate with you when you're raising funds. And Ed will kind of take you through the topics which maybe have a more of a regulatory or IP focus. Some of the other workshops in the past 2 days of this conference, such as those by the investment firms, have kind of focused on what's investable and who to ask for and who to approach for investment. So we're in this workshop, we're kind of aiming to cover more of what you're going to expect when you're negotiating with an investor, kind of the terms that they might demand in exchange for their investment. So if we go to slide. So here we'll go through a few of the common kind of structures that you might have when you set up your business. So the most common one, or the one by default, this is the baseline scenario, is a sole trader. So if you don't have any legal structures set up, and you're bootstrapping it essentially, you'll most likely just be a sole trader. That's trading in your own name. It's no registration required, obviously, because this is essentially just you. You are the owner. You are your own boss. And anything you owe to your suppliers is owed by you personally, and any profits you get to keep in your name. Pretty simple. So the biggest upside is that it's really easy. You don't need to do anything. This is kind of like the default scenario. There's no registration, no annual filings, except taxes, and what you say goes. But one of the main downsides is that a third bullet point right there. Usually as gamers, the term unlimited is usually a good word, but this is one scenario where that is not the case. You will basically, if any debts that you have, obviously, that stem from your business, can be taken from your own assets because you are essentially the business. And obviously, the business ends with you.
So, and these two are two further major downsides for being a sole trader. While it's possible to kind of sell your business as a sole trader, you'll just sell all the assets of your business. It is more difficult. So, I mean, a sale of assets in itself is kind of, it can be messy, at least more messy than shares, because you won't just have your pieces of software, your code or your game. You'll have maybe contracts with your suppliers. You might have contracts with your employees and your customers. So all those need to be kind of transferred when you sell your business as well. And other questions can pop up, like during your time when you're growing your business, have any personal assets been mixed in? Have you used any of your personal assets for business use? Who is that part of the business? How much of the reputation or goodwill of the business is tied to your own name, which might be kind of hard to separate once you're trying to kind of give that value to someone else. Another major downside is that it's much more difficult to attract investment, especially from the several VCs in this building right now. It's simply put, it's just much easier to invest in a company. And we'll go into those reasons a bit later. But another common structure that I probably just want to quickly cover off first is a partnership. So this is relatively uncommon, I would think, in our experience, in terms of kind of startups, just because the most popular option is a company. But in general terms, a partnership is two or more people coming together for a joint enterprise. So by default, you don't need to register a partnership, but what the partnership will be governed by, aside from the Partnerships Act, is what's called a document called a partnership agreement. So you'll have that with your partners, and that will kind of govern the terms of how your business relationship goes. The owners will be partners. You guys will kind of take on all the kind of profits and the debts of the business. It's basically essentially just two people or two or more people working together in a business in accordance with a partnership agreement. So, because there is no registration, there's a partnership. In a partnership, each partner will be personally liable for the debts incurred by the partnership. So that includes you as a partner or your partners. So you guys will each be responsible for each other's debts in that business. And in terms of how long a partnership lasts, so if by default, if a partner dies, then the partnership is dissolved, and if the partnership agreement doesn't say anything about it, then the assets will be distributed between the remaining partners. And it's not obviously, because this is kind of just like kind of like a multiple sole trader situation in a sense. It's not easy to sell a partnership, nor is it really easy to kind of invest in either, which is, I think, the next point. Yeah. So similar issues to a sole trader in that sense. It's governed by the Partnerships Act. Just so you're aware, that's the act that governs these kind of entities or these arrangements. And I mean, a common example of partnerships is law firms. I mean, you got you can say, but like Hudson Gavin Martin is a partnership essentially. So I think that's just a historical thing at this point, that law firms are built as partnerships rather than any other structure. But there's nothing really stopping them from being structured as a company, just because of all the or the cons that we've outlined so far. There's a type of partnership that's kind of quite similar to a company. It's called limited liability partnership. It's where you kind of have a general partner who acts on behalf of the partnership, and then you have all these other partners called limited partners in the shadows who don't take any liability. So in a sense, that's kind of similar to kind of a company, but again, relatively uncommon for the types of businesses you guys will probably be kind of trying to grow. So we won't cover that too much. But what we will cover is the most common vehicle for enterprise in New Zealand. That's the humble company. So it's a simple concept. A company can own assets and it can do business. And if you own all the shares in the company, you own the company. And the shares can be distributed or divided among different people. And so you can have multiple owners of the same business. You don't need a lawyer to set up a company. Anyone can do it. It's actually quite easy. The company's office website has some very clear guides, and it costs under $150 to register a company. So New Zealand is actually one of the places in the world that has the most, the highest ease of registering a company, really. The difficult part, though, comes after that. It's all the documentation that kind of surrounds your company and governs how it runs. So that up there, it mentions a constitution. So it's not required, but the constitution is a document that sets out rules that your company has to follow, such as how to appoint directors, how shares can be issued, how documents can be signed by the company. So while it's not necessary to have it, if you don't have one, then the default provisions in the Companies Act, which is the legislation that governs companies in New Zealand, the default rules in there will apply. If you don't have a constitution setting out your own kind of rules on how you want to run your company, and a constitution is kind of the only way to change certain default rules in the Companies Act. For example, if you want to change how directors are appointed, then you'll need to have a constitution and have that constitution state that alternative way of appointing directors. So, and the second document up there that's mentioned is a shareholders agreement. So that comes into play when there's more than one shareholder. Obviously, if you're the only shareholder, you're the boss, so you don't need to have an agreement with yourself. But when there's more than one shareholder, that document governs the relationship between the multiple shareholders and setting out rules of how each shareholder must exercise their powers to run the company, such as who can appoint how many directors, when shares can be issued. Those will be the things that you agree in a shareholders agreement. Owners, obviously, the shareholders, but there's a point of difference here in that the management is by the directors. So as shareholders, you do not typically manage the company unless you're also a director. The directors will kind of take care of the day-to-day, but the profits and stuff will go back up to the shareholders, who are the owners. And a lot of smaller companies, the directors kind of typically are the shareholders, and vice versa. But in larger companies, you might, it's obviously not really practical to have a board, like say if you have 15 shareholders, it's not practical to have a board of directors of 15 people. You'll never get anything done. So there's that slight distinction there between ownership and management. Cool. So one of the main attractions of having a company is limited liability. While it's possible to incorporate an unlimited company, the vast majority are limited liability, and which means that you, as shareholder of the company, you're not personally liable for the company's debts by default. The company, if a company can't pay back its debts and it goes into liquidation, the company's assets will be basically liquidated and sold, and the company will be dissolved, but your personal assets would not be in that equation, so they would be safe. This is to basically encourage enterprise, allow entrepreneurs kind of take a bit more risk without risking everything they own. But do note that the limited liability aspect is just the default position. If you have been taking on, as a director of the company, if you've been taking on debts that you know the company can't pay, for example, then you may actually be personally liable. So it's not a get out of jail free card for every scenario, but for most scenarios, if you've been operating your company properly, you have the benefit of limited liability. So, in terms of lifetime, the company lasts until it's deregistered, so unlimited, and actually a good unlimited this time. Shareholders and directors can change, which is quite pivotal to investment. So that's the basics of the company. In terms of the additional benefits, so it's another major benefit is that it's actually really easy, and I say easy in a very qualified sense. So imagine multiple quotation marks around there. To sell the business, because you just need to sell the shares in your company, and once you do, the whole business, so that liabilities, employees, assets, everything passes on to the person who takes on those shares. So that's why with a company it's much easier to kind of move your business around in terms of ownership. It's also much easier to attract investment because you can offer them shares rather than just say to the investor, hey, here's my personal checking account, send me a small loan of $1 million, and I promise I won't be in the Bahamas tomorrow morning under a different name. It should be a two-way ad, really. But the main piece of, so hopefully that's kind of self-evident. The main piece of legislation that regulates companies is Companies Act up there. If you ever become a director, you'll have director duties under that act. So if you ever do become a director, you'll be somewhat familiar with parts of it. But this is just a note where your obligations might lie and where to find it. Let's see. What do we got? Oh yes, the Constitution. So a Constitution is a public document because it's publicly viewable on the company's office website. So it's for this reason that kind of people prefer to have arrangements with their fellow shareholders regarding, say, share issues, who can appoint directors, etc., in the shareholders agreement, which is a document that's not public. Some academics might say that kind of defeats the point of a public constitution in the first place, because a lot of people will just have a constitution that says, I don't know anything, refer to our super special secret shareholders agreement, and then that's all it says. Kind of like a, sorry your princess is another castle kind of moment. But that practice is very common, just to have the terms of your relationship with your shareholders in a shareholders agreement that's not publicly visible. And it says up there, let's see, can change the default rules in the Companies Act in the 4th bullet point. So an example of the default rules that you might want to change are, say, preemptive rights on share issues, certain powers, and certain powers can only be exercised if you have a constitution that allows you to do it. Kind of like getting director and officer insurance, indemnifying a director. You need a constitution in order to kind of be able to do those things. And let's see, similar to a shareholders agreement, the Constitution binds the company and all shareholders, but one difference here is that the Constitution is a document that's referred to in the Companies Act, and which the Companies Act grants certain powers to. So it has so some of the rights and obligations in a Constitution will have kind of statutory backing in that sense, whereas a shareholders agreement is simply a contract between you and your other shareholders. Last point there, amended by special resolution. What that means is that a constitution needs more than a simple majority of shareholders to modify. This is to kind of protect the minority shareholders' interests. So you can't just have a 51% shareholder who controls the company and just bullies the others by putting whatever terms they want in their constitution. So a special majority here, a special resolution requires a majority of at least 75% rather than 50%. And move on to a shareholders agreement. So as mentioned before, it's a private document. It's not available to be viewed publicly unless you, I guess, choose to disclose it to whoever. It's like an extra contract on top of a constitution, mostly because mostly because constitution is public. You don't, maybe there are some terms that you don't want to be reflected in the constitution. But note, so that's what it says, complements constitution. But note that new shareholders aren't automatically bound by a shareholders agreement. So that's one difference between this and the Constitution. The Constitution, again, is a document that's referred to in the Companies Act, and one of the rules in there is that any person who becomes a shareholder is automatically bound by the Constitution. That's not so for a shareholders agreement, which is merely just a private contract between you and other shareholders. So if a new shareholder comes on, they'll need to sign what's called a deed of accession, which is basically a piece of paper saying, I agree to be bound by the existing shareholders agreement. It's pretty simple. And usually it's amended by unanimous consent because you guys all agreed to some terms. You don't want some less than 100% contingent being able to kind of unilaterally amend those agreed terms. I mean, sometimes we do see it be lowered to less than 100%, but it's quite rare. And so for this bit, these are just some of the kind of common matters that are addressed in a shareholders agreement. Issuing shares, very key point to address in the shareholders agreement. You don't kind of want the directors of the board to be able to issue shares without restriction, because let's say you own a certain percentage of the company and they start issuing all these shares and they don't issue the shares to you, then your percentage holding will go down, and therefore your control of the company will go down. So there's there are always kind of rules in place to kind of make sure that any share issues are under terms that you've agreed to when you signed the shareholders agreement. So second bullet point there is preemptive rights. So what preemptive rights are, and preemptive rights can apply to share issues and share transfers. So let's say there are preemptive rights on some share issues and you want to issue some shares. What the rights mean is that you must offer the shares to all existing shareholders in proportion to their existing shareholdings before you can issue or transfer those shares to anyone else. So let's say I have 20% of a company, Ed has the other 80%. If the board wants to issue shares, say 10 additional shares, they'll have to offer 2 of those shares, new shares to me, and then 8 of those to Ed before those shares can be offered to any other third party. So that's what preemptive rights are. They can apply on share transfers or share issues. So, I mean, the main purpose of preemptive rights is that it's an anti-dilution mechanic. So as long as when you're offered shares, as long as you accept and kind of pay that money for those shares, you won't get your shareholding diluted. So it gives you an opportunity to keep your shareholding where it is, which is why it's a common feature in shareholders' agreements. When the board issues shares, you want to have a chance to be able to kind of keep your stake in the company at where it's at, without so that the board can't forcibly kind of just dilute you to nothing by issuing a gajillion shares. Tag along and drag along rights. So this is another common feature of shareholders' agreements, and pretty important, I think, for especially the private equity investors that might come in and invest in your business, because this relates to exits or basically selling off the business. It usually triggers when someone tries to, well, both categories of the tags and the drags will typically trigger when someone tries to sell off more than half of the shares in the company, or substantially all of the assets in the company. So when someone tries to sell off more than say 50% of the shares of the company, the tag along rights mean let's start with the drag along actually. The drag along rights means that the people who are selling that majority stake in the company will have the option to force everyone else to sell alongside them. This is important because when a big company comes to buy your business, they don't want 50%, they don't want 60% or 70% and left with some random 10%, 5% shareholders. They want 100% of the company usually. And there might be situations where you can't get approval of every single shareholder to sell, because you might have a random shareholder who has 2% of the company and they want to hold that for life. Well, you can't if you have a drag along clause. You can basically, if you say you and your founders hold 70% and you sell off to some big company who wants to buy your business, you can drag all the minority shareholders along, so you have to sell. And that's what a drag along right is. On the other side of it, if in the same scenario you sell a majority of your company and you decide not to drag everyone along, a tag along right is the right of the minority shareholders to kind of tag along with your sale, so they can force you to sell their shares along with yours. But otherwise, you can't sell your shares to that big company. So if in that same scenario, if that 2% shareholder really wants to get out and sees that you're selling 70% of the company to a big company, they don't know who this new company is. They don't want to be business partners with them or something. They'll just say, hey, I'm invoking the tag along right. You have to sell my shares along with yours at the same time, otherwise the deal's not happening. So that's what a tag along is. And as I said, it's quite important for exits. I've had deals. Basically, it's not an issue if everyone is on the same page, but unfortunately, especially when you get to a more mature state in the business and you have a lot of shareholders, everyone might not be on the same page. And I've certainly had cases where minority shareholders were very adamant that they shouldn't be selling the business. They don't like who the business is being sold to, because they'll just ruin the business that they built from the ground up, but they only hold 5% of the company. So the the majority shareholders, in that case, can still make the deal go through by invoking the drag-along rights and just drag them along for that sale. So that's quite important for, and I think that's kind of a theme of the shareholders agreement and constitution. It's not really that effective or useful really, if everyone's on the same page and everyone's happy. But when there are disagreements, this is something that you can turn to, and it will save you a lot of headache if there is an disagreement. Employee share schemes. So what these employee share schemes or employee share option schemes, they're ways to incentivize performance and retention of staff, usually. And usually what happens under these share schemes is that employees are offered shares in the company for maybe staying in X number of years or achieving certain KPIs. This is actually a somewhat tricky area of the law. It's very common because the salaries that you might pay someone when your business is growing is not may not be competitive with the market, but the employees might believe in the company. So what you can offer them is basically shares in your company to kind of make up that difference between their salary gap with the market. But yeah, it can be a tricky area. So in a corporate sense and tax-wise, especially because when you give shares to employees, they'll have their own tax implications. So it's important to kind of engage lawyers and accountants and make sure they talk to each other for this step. If you ever want to do an employee share scheme, and it might be the case that if an investor comes on board, they might suggest an employee share scheme to you because they'll be doing their due diligence in your business. They might identify a few key people, and they will say to you, hey, I think these people are really key to the value of the business. We want to keep them around. How about we set up an employee share scheme to kind of keep them around for longer? So that's why that's there. Good and bad leaver provisions. So these kind of provisions are for when employees, shareholders who are also employees, so employees that also hold shares, leave the employment of the company. So typically what these clauses try to do is that if that person left the company and they're a good leaver, you might allow them to keep their shares. But if they leave the company and they're a bad leaver, i.e. they fired for misconduct, dismissed on basically they left on bad terms with the company. You can define bad leaver how you want really. But if they are a bad leaver, then typically we kind of see that the company has a right to buy back their shares at a discount. So basically just to incentivize, don't be, when you leave the company, don't be a bad leaver. Sometimes we see companies that only want people who are actively contributing to the company to be shareholders. So sometimes we see that even if they're a good leaver, the shares will be bought back as well. So it just depends on what you want and what works for your business in that scenario. And common issues between shareholders. I wonder what the next slide says. All right, it's this one. Okay, so you're bringing on a new investor with the company that you've set up, and you're going to issue them shares in exchange for cold hard cash. You know the terms of how you're going to run the company, so you've got the terms of you're aligned with the investor on the terms of your shareholders agreement, but there are a few more hurdles. One of them is, did you get that constitution in place to get around the default preemptive rights in the Companies Act. As I mentioned earlier, the Constitution is a way to kind of amend the default rules that apply to your company. If you don't have one, you'll be bound by the default rules, one of which is Section 45, preemptive rights, which is you must offer any new shares that are issued to existing shareholders in proportion to their existing shareholding. So we see a lot of constitutions that just have a line in there saying Section 45 of the Companies Act doesn't apply, just because they want to have their own. It doesn't mean that there are no preemptive rights. They might just want their own special version of preemptive rights in the shareholders' agreement. And the second hurdle that you'll face is that issue is a third bullet point there around the Financial Markets Conduct Act. So issuing shares in a company is actually a regulated activity in New Zealand, and that's the act that covers it. The default position is that you'll need to prepare a huge disclosure document called a product disclosure statement, or formerly what was known as a prospectus, which is very, very expensive to prepare. It can, in fact, go into the preparing it can go into the 6 figures in terms of cost, and that is unless your investor fits into one of the exemptions in the Financial Markets Conduct Act, or FMCA. The exemptions kind of cover the common categories of people who would usually invest. So, family, close business associates, very experienced investors, kind of like the investment funds. So, the rule is really just to kind of protect investors or mum dads who might be approached by shady companies offering them shares. So the intention is not really for everyone who is offering shares to prepare a huge disclosure document, but really for everyone to kind of just look at their investor and say, hey, is this person the kind of person who would kind of go into this investment with their eyes open and know what they're getting into? I think due to the intricacies of the exemptions in the FMCA, because even if you are exempt, maybe the exemption is only a partial exemption, you still have to comply with some disclosure requirements. It's probably best to consult a lawyer before you issue shares. And the fourth bullet point, different methods of raising capital. So it's not just issuing plain shares being your only option. If you want, the opportunity to maybe earn some of the shares you've given away to your investor back, maybe you can do a convertible note, which is a loan that has a possibility of converting into shares in the future upon certain events occurring. And if the company does well, the company may be able to kind of pay back the loan and not have to issue any shares at all. So you might not end up giving away any control of your company at all. So there are a few different types of arrangements, depending on what your needs are. You don't necessarily need to just straight up give away shares. There are also another common document. I'll just mention it for completeness. Really, is called a SAFE, or SAFE. Or which stands for Simple Agreement for Future Equity. It's quite a document. It basically says an investor is going to give you cash now, and it's not a loan for a chance at buying shares at a discount in a future capital raising round. It's quite So it's quite a one-sided document, but it's made so that you can quickly invest, and to no one's surprise, safes are an American invention. I think one point I want to mention here is that when, and probably more probably suited to the investment fund talks is when you are onboarding an investor, it's pretty important to make sure that your values align. At the end of the day, money from one fund is the same as money from another fund, but if your values don't align and your expectations are different, that can cause a lot of attrition and very this can cause a lot of attrition in the business, and or make basically your journey to where you want to be that much harder. So one thing is definitely just don't be blinded by the dollar signs, and make sure that whatever fund or whatever investor you're getting on board can help you. Maybe they have connections that are relevant to your industry, experience that's relevant to what you're trying to do. That's all probably all as important as the money that's coming in. In an ideal scenario, anyway. If you want further funding after after onboarding an investor, you might your first port of call is probably your existing shareholders. Basically just usually an email going around saying, hey guys, ran out of money again. We'd like to offer you some shares if you want to give us more money. Or a bank, but it depends, because the banks will only loan to kind of businesses that they know that can pay pay them back. So that's why first port of call is usually your shareholders if you're in dire straits, especially if the banks don't want anything to do with you. Personal guarantees. These are usually requested when the lender doesn't believe that the company has actually enough assets to support the money they're giving you, or the loan. So they would want to be able to come after your personal assets if the company goes under. Needless to say, avoid giving personal guarantees where you can, because that kind of defeats the purpose of the limited liability in a sense, which is one of the benefits of having a company. Last one is, when one party wants to exit. So exits, there are a bunch of ways to exit, or basically, have your big payday. That's what it is. Your business. It's if you have a company, easiest way is just to sell all the shares. You can also sell all the assets of the company as well. You can have an IPO, although probably not very relevant for gaming studios to have an IPO, because then you'll need to answer to mum and dad investors. You have thousands of investors maybe, and you'll need to tell them why you've been cash flow negative for the last 5 years, and say, I promise that this new game will bring all that money back. It's a very hard situation to explain. So that's exiting business. But as you can see, all the concepts that we've kind of gone over kind of apply when you're exiting a business. So, which is why it's useful to have that shareholders agreement and constitution in place. Let's see how we're going for time. More common issues. Dispute resolution. As I said, the shareholders agreement is most useful when there's a dispute or disagreement, or about to be. So that's why one of the typical clauses we see in there is a dispute resolution clause. Basically, it's in there because going to court is very lengthy and very, very expensive. Some clauses require the dispute to be resolved by alternative methods, such as arbitration, which reduces lengthy and expensive to just expensive. You can also, just require good faith discussions and mediation beforehand. But yeah, that's kind of why we kind of see those clauses in there. A restraint of trade, again, very important. Going into the business, I'm sure everyone will want to kind of protect their investment. Restraint means that is basically restraint / non-compete basically means that for the period of time while a person is a shareholder and for X number of years afterwards, maybe, they can't compete with the business, take any of your employees, take any of your customers. That's how the restraint usually goes. So that's kind of, it protects the business because obviously as a shareholder, you have access to kind of all the company secrets, all the knowledge, all the customer client lists, etc. So a shareholder who has all the company secrets can't just go out, use that knowledge, and create a competing business. Maybe without all of the existing debt of the company that was required to get there in the first place. And note that one thing to note with restraints, though, is that the time and geographical restraint needs to be reasonable in the circumstances. You can't go. You're not allowed to compete with us anywhere in the universe and for the history of forever, because you're essentially taking away someone's livelihood, or potentially, and the courts would just refuse to enforce something a restraint that's not reasonable. As for when a restraint would be reasonable and when it would not be, probably best to consult a lawyer at that point. Yeah, I think that kind of covers the kind of terms that you'll probably be discussing with an investor when you're looking to raise funds, generally at least. Any questions before we move on to kind of the more IP and regulatory focus sections? This one.
Thank you very much. I just wondered if you could recap or extend a bit on the agreement an opportunity for someone to invest cash now with opportunity to have reduced cost shares later on, you explained?
Oh, do you mean, sorry, I couldn't quite hear it, but was a question around a convertible note where you kind of have a chance to kind of, whether you can get some money now, but you have a chance to kind of get the shares that you offered back later on. Yes,
if you could explain that and repeat the name of that, just so that you're not giving away shares straight away.
Yeah, so a convertible note is basically an instrument. It's a loan, essentially, but so it will have, interest rate, loan term when you need to pay it back. But on top of that, it will have the option, or under certain circumstances, the loan can convert to shares in the company. Whether that's a scenario that you want, i.e. you don't want to pay them back, you just want to give them shares, or whether it's something you don't want, i.e. you want to be able to pay them back and not give them shares. That's something you negotiate with your investor. But you can basically just at the root of it, it's a loan that might convert into shares under certain scenarios. For example, if in the next capital raising round, if you or let's say if you don't within the next couple of years you don't reach a certain revenue target, then the investor might be like, well, that's bad news. In that case, we don't want shares. We just want our money back. Whereas if you want to if you want the investors to take on shares and you don't want to give them money back, you might say, hey, if we hit X revenue target in the next say 2 years, then you have to take shares. We're not giving you your money back. Or if you don't want them to have shares, you can say, then you have to. Then we'll pay you back, and you can't take shares. You have no option to take shares. So it's really kind of like a share arrangement, a share offer arrangement on top of a loan. If that makes sense. Sure.
Thank you. What is the incentive to the investor to? It sounds like those terms are perhaps aligned more with the IP owners to their benefit rather than the investor. How do you make it fair in that situation?
How do you make it
fair so equally attractive to both
So yeah,
parties?
it depends. That's more of a commercial question, really. Whether an agreement is fair will basically be a discussion between you and the investor. But it will depend on the leverage each person has. If your company is going under, well, about on the verge of going under, and they're a lifeline, I mean, they're going to have a lot more bargaining power than you will. And in that sense, what's fair might tip in their favor. So they might say, okay, if you don't perform this well, we're going to have our money back. And we'll only take shares if we want to, and we can do so at any point in time in the next 2 years, let's say. And you might just have to kind of swallow those terms if you're really in dire straits. On the other hand, if your company is projected to do really well, it's a really innovative idea, or the game is in a space which is growing and it has a lot of interest, a lot of traction, and you have like 10 investors lining up to get to you, you have a lot more leverage in that case. So you'll say, hey, I don't really want to give away shares, but if let's say if you help us, get this many customer connections, then we'll give you this many shares, let's say. So it's a very variable kind of like contract in terms of what you can set as the triggers for it, and whether you give shares or you pay back the loan. But it's just another way to kind of offer shares in circumstances where you I guess you have a chance to kind of get them back, really. Oh, one second.
So you mentioned with preemptive rights. So if an investor was to join in and get new shares would be issued, and existing shareholders would get like a amount relative to how much they own already, where would the amount that the investors get come from? Because like if someone had 80%.
That is a very good question, and probably something I should have addressed so I mentioned the two concepts, but there's a bridging concept in the middle that I probably should have addressed, which is that the preemptive rights will apply, but what typically happens is that you go to your shareholders and say, hey, we need cash. We have a big investor coming in. I need you guys to all waive your preemptive rights so that we can offer this new investor the number of shares in the company that they want. And then typically all the shareholders will go, that sounds great, we'll waive our rights. And then you can issue straight to the new investor without having to go through the preemptive rights process. So that's typically how it goes.
Okay, thank you.
Cool. Any other questions on terms in your shareholders agreement, or capital raising in general, or company structures in general? Cool. Excellent. If nothing else, how are we going for time? Do you think we want the 10-minute break now, or
10-minute break? Or should we just... Right.
Yep.
Yeah,
Cool.
okay.
All right.
Go for it.
Take a break now, and we'll be back in 5 to 10.
Yep.
Yep. Sorry, I'll put on the next one. So yeah, next bit is IP.
Cool. Okay, so what I want to do now is just quickly talk about the different types of intellectual property, because I think it's really good to understand what it is so that you know what you have as part of your business. So generally there are two types of rights. You can have them unregistered or registered. So the unregistered ones are copyright and confidential information, which essentially means you don't need to register with any government authority or other organisation to have that right. So you basically get it, you have it automatically. The other one is where you can register these IP rights, such as patents and trademarks, and that is where you do have to go to a government organisation such as the New Zealand IPONS, which is the Intellectual Property Office of New Zealand, to register those rights. Sort of like, if you register a domain name, for example, you'd register that name with a domain name register. So I'm going to talk about copyright, confidential information, patents and trademarks really quickly. Starting with copyright. So copyright basically protects the literary, dramatic, musical and artistic works. So this covers a whole range of creativity. So it could be your, the writing, the software that you're developing. So all of the software that you have, you've got your source code. So that source code is actually a literary work, which is automatically protected by copyright. In your game, you might have like photos, drawings, films. I talk about clothing designs because you might have, say, you have merchandise for your game characters, whatever it might be. Those designs are all protected. Photos, statues, three-dimensional objects, all of those things are covered by copyright. So with copyright, there are certain requirements, right? So the first one, it must be original, so you have to have created it yourself and not copied somebody else's work and not infringing someone else's work. There's a very low threshold to get copyright, so I just can't draw to save myself, but if I drew a stick figure and made it pretty and all that kind of stuff, I'd have copyright in that work. So like in my third point, it's actually not merit-based. It could be totally rubbish or it could be an amazing piece of work. I'd still have copyright in that. So the idea is that copyright is the expression of the idea. I have an idea which is not protectable. So all of us in this room will have ideas. We can't protect that. But the minute I put it down on a piece of paper, I draw a picture, I take a photograph, I write some code, I'm expressing that idea, and so I have copyright in that. So the value of copyright is that once I've got copyright, so some of you here are taking notes, you've got copyright in all of those notes, right? Once you've done that, you can stop people from copying those notes, from issuing copies, from selling it, communicating that work to others. So it's a really powerful right that you have, which you don't have to pay for it at all. You can, like in some jurisdictions like the States, you do, or you can register it, but here in New Zealand, you just get it automatically. And as the owner of the copyright, what that means is that you're entitled to sue for damages. So if I, develop some code for my game, and then I find out that someone's taken it and used it in their game, I can basically stop them from using it, or I can sue them for the use of that code because they've infringed it. So generally the owner of the copyright is the person who creates it, so that's the author, but there are two exceptions. The first one is if you're an employee in the normal course of your employment, right? The employer of that employee is the owner of the work. So if I'm a game studio, I employ all of you to develop code, create content, photographs, whatever it might be, then under your employment contract and under law, all of the copyright would be owned by the company. There is the other scenario is where you're a contractor, not an employee to the firm. So you contract as an independent contractor to a studio. In that case, carrying out the owner is the author unless that contractor has carried out a commissioned work, in which case the commissioner is the owner. So if I'm the game studio, I'm commissioning you as a contractor to create some work for me. Then in that case, we would be the owner of that work. So transfers of copyright, the owner is the author also unless the transfer of copyright is by agreement to somebody else. So you can agree any other rule that you like or whatever it might be. So I might say Calvin owns the copyright or you own the copyright. In that case, you can change it by agreement. So the great thing about copyright is it's automatic. You don't have to do anything. There's no registration, and it's free. And it's basically long duration. It's the life of the author plus 50 years. So that's a very long time to stop somebody from copying your work. However, you must prove your ownership. If you want to enforce it, you've got to prove that you created it yourself and that you've got to show the originality. So the idea here is that you need to keep records to show that you developed whatever it is that you created. Another con about copyright is that it does prevent copying, but it doesn't stop independent creation. So all of us in this room could create something which is the same as everybody else's, but it doesn't stop you from making a claim against that other person. If it's independent creation, then everyone has that copyright in it, right? And so I might come up with a really good idea for a story for or a script for a studio for a game or a movie or whatever it might be, and someone else can come up with the same thing. So there's no breach of or infringement on copyright there. So that's one unregistered right. The other one, which I talked about, is confidential information. I think we all sort of know what this one is. So this is basically confidential information that we have, or trade secrets. And essentially the requirements are that the information must be of a confidential nature, such as like your business plans, your ideas, customer lists, or financial information. And that information is communicated in confidence. Generally with confidential information, you'd protect that through non-disclosure agreements or confidentiality agreements. But having said that, even if you don't have that in place with whoever you're dealing with, you can still make a claim under law for a breach of confidence. So you don't. So there is a concept of a breach of confidence where you can say, well, I gave you this confidential information and you've taken that, given it to someone else, and I've suffered loss. So, but you don't want to go there. You probably want to rely on some kind of NDA that you can say, hey, look, you guys sign up to this. So in terms of confidential information, the great thing about this type of right is that it's totally within your control. If you don't want to give confidential information away, you don't have to. You control what you give to your investor, your third-party developer, whoever it is that you're dealing with. It's not territorial, so you can basically control and have this right anywhere in the world. So it's not like this information is only confidential if you're using it in New Zealand or Australia. It's basically around the world. It's also free because you don't have to register anything, and it's potentially indefinite as long as it's not publicly disclosed by you. Some of the cons with confidential information is that it does not prevent independent creation. So again, if we've all created the same sort of thing and without breaching anyone's or infringing or breaching confidential information, then that doesn't actually stop someone else from creating something similar. Now I'm going to talk about the registered rights, and probably the next important one in relation to copyright in your work is trademarks. So this is basically protecting your brand identity. So take, for example, electronic arts, right? So electronic arts will be a trademarked word or a brand. So they've got protection in relation to the name of the studio, as well as all of the 100 games that they have. So you can, in terms of the protection that it gives you, it protects your business because other people can't use your brand. So you think about Apple, McDonald's, Coca-Cola, all of those businesses with really valuable brands, they've protected their branding through trademarks or registering the trademark. So with the trademark, the requirements are it's got to be a word, a picture, a logo, or a sound, and it must be distinctive. So you can't be using things like descriptive words or words that are used in the trade. So you can't register a game called the best game, or you can't say register like a pizza. If you were a pizza shop, you couldn't register Supreme Pizza, because that's just a descriptive word of the name of a pizza. So you'll see that with a lot of trademarks, they are quite distinctive, particularly the registered ones. So what it does is it prevents, if you have a trademark or a registered trademark, it prevents the use of same or similar signs on the same or similar goods. So basically with when you register the trademark, you get these particular rights. So here are some examples of trademarks which are registered. Now I'll quickly tell you the difference between the registered and unregistered. If you have an unregistered trademark, it just means that you don't pay for it, you haven't registered at the Intellectual Property Office of New Zealand or, say, around the world. Essentially means that someone else can come along, come up with your same trademark and essentially have the rights to it. But these are examples of some registered trademarks. So once they're registered, you're not able to use the same trademark within that particular category that they've registered it in. For example, you could register the word like fortnight, which means that anyone in this room wouldn't be able to use the name Fortnite because it's registered by the owners of that. You've got a device mark, which is essentially the logo. So this one here is the Sony PlayStation logo. So we wouldn't be able to use that because it's already registered by Sony. You can register a shape as a trademark. So it's the iconic Coca-Cola bottle, the colour purple, Cadbury, for example, the Cadbury purple. And also there's just because it's just come out, the Barbie pink, the actual colour pink for Barbie. There's also sounds that you can trademark. For example, you look at the Star Wars lightsaber sound. When you turn the lightsaber on, that's trademarked by Lucas Arts. And then you can also have smells as well, like cinnamon for pharmaceutical products. So totally random things that you can register. But for a studio, you're more likely to be looking at trademarking your words, so the name of your game, and like the devices, like the actual logo itself. Good thing about trademarks is that they're indefinite. You can basically keep it as long as you keep paying the fees, and it's relatively cheap to apply for and maintain, and it's a powerful marketing tool. The cons are it's territorial, so you need to get a trademark for pretty much every jurisdiction in which you're trying to protect it. So you might have to get one from New Zealand and Australia and the US, wherever it is that you might be trading. It is also an exclusive right. It's not a monopoly. So you've got a right in a particular class. So there are a whole lot of trademark classes, and you need to register in one of those classes. So for gaming studios, they might go into this software class as opposed to, say, fruit and vegetables or whatever it might be. I'm just going to quickly go through patents because it's good to know what they are, but they're probably not relevant for sort of what we do in terms of as gaming studios. Essentially here in New Zealand you can't get a software patent, but it's good to know what they are, because a lot of the times you'll have investors in your gaming studio and they'll say, show me your patent. And you're like, well, hang on, we don't have one because you can't get one here in New Zealand. So basically a patent protects invention. So an invention or a patent has certain requirements. For example, there has to be some kind of application or a utility or a use. It's not just an idea. And there must be some kind of inventive thing to it. It can't be, oh, well, it's just so obvious everyone would have known to have done that. And it must be new compared to what's known in the industry. So essentially, you see patents in like hardware or equipment where there's quite a novel and a new way of doing things. You might have a really cool washing machine or something that has a whole lot of patents in there in terms of how it washes your clothes or whatever it might do. And what that does is it protects you from unauthorized making, using, selling, or importation of that invention. The good thing about patents is that they're basically it's an absolute right. Once you've got it, you have it in that territory, but they're very expensive to get. It takes time to obtain the territorial, which means you have to get a patent in each jurisdictional country in which you want to protect that patent, and it's only 20 years protection. So you look at the, those Nespresso capsules, right? Nespresso, I think it was Nespresso had the capsules. They had a patent over that, and so basically you had to get everything from Nespresso. And then a few years ago, the patent ended. So now you start seeing all of the generic pods. So that's why after 20 years or whatever it is, you basically anybody else can copy it and make the same sort of thing. And the other thing is, with a patent, you need to tell everyone through part of your filing how it works. And so one of the drawbacks is that you're going to tell everyone how your invention works, and so people are going to know how it works, and then they'll copy it and sell it, create knockoffs and all that sort of stuff. And so then you're going to have to defend it. Then you're going to have to try and enforce it. So you've got to have a pretty decent war chest to do that. So basically, just keep everything as a trade secret. Just quickly on corporate structuring. So those are the types of intellectual property that you'd have. Like I said, it's copyright and brand trademarks that are important to your game studios, also your confidential information. Just quickly on licensing. Typically, what we see is you have a company that is set up which owns all of your IP in the in your game. So your IP could be a domain name, your copyright, and your code, the trademarks, all that sort of stuff is owned in one company, which is up there called the IP owning company, and then it sets up companies beneath that holding company, which are the trading entities. So the trading entities is just like another company which is set up, and that does all of the contracting with your end user customers. Okay, and so what that means is if something happens, you're being sued by a customer or a supplier or your employee, essentially they're just suing your trading company, and it doesn't affect any of the IP which is sitting in the company above. Okay, so the one in green, for example, might be a trading company in New Zealand. You might have another trading company in the US, and you might have another one in, say, the UK. So the whole idea is to try and manage your risk. Cool. So that's all about real quick rundown on what IP is. Now I'm going to talk about some other exciting stuff, which is around your actual game itself. So we've talked about the company, what IP is, and now when you're developing the game and licensing it, what do you need to consider? So I'm going to talk about things like what you need to look at in terms of the contracts when you're developing the game, how you license the game to your end users. Quickly talk about user-generated content and real-time chat as it's used in games, and also just generally complying with laws. So when you're developing your game, it's important that you understand what you're entering into with your platform operator. So this could be Steam, Apple, the Apple App Store, the Google Play Store, as well as the engine provider. So you're developing your game in Steam, Unity, Unreal Engine, or whatever it might be, right? So the first thing you should do is at least have a look at their terms and conditions in terms of what you can and can't do, because they will set out what types of games that you can say upload to the Apple App Store. You know, I had a client who was creating a game years and years ago, and they thought it was the best thing, which is for them it was, but they couldn't get it into the Apple App Store because it was not a family-friendly app. They could get into the Google Play Store, and so they'd spent all of this money on creating an iOS version, but it was rejected because it wasn't family-friendly. So you just have to go through and have a look at what those requirements are. You should also have a look at what the terms say to see if it prohibits you from developing games with a similar look and feel to other games. So there might be, I'm just using this as an example, I'm not saying that it does have them, but let's just say Apple terms and conditions had something like, you know, you can't create a game that is similar to anything in the Apple Arcade, you know, store or something like that. I have seen terms like that. I can't remember if they're in the Apple ones, but they do prohibit you from creating similar games, or even whether or not you can license your game on a competing platform. So it's always good just to have a look at those T's and C's for the platform that you're using and the engine that you're running. In terms of the, if you outsource some of your game development to a developer, it's always good to understand what you've agreed to with that third party in terms of, for example, who owns the IP. Now, I'd always have the IP ownership with the game studio who's creating the game. So if I get one of you, if you guys say game developers and I contract it out to you, I'd expect all of that IP to come back to me or to be owned by me. And the reason being is that if I don't own it, then it's going to be really hard for me to sell that business to, say, Microsoft, because I've got the next Minecraft or whatever it might be, because they'll want to know that you own all of the IP, or at least have the rights to use it. The game development agreement will also cover things like how that game is tested, as well as the game assets. So as I said before, in terms of how the IP works, you want to make sure that the IP in the game that is created belongs to you or your company. And as I said, in terms of if you get your employees to do it, then it's owned by the game studio anyway, as the employer. And in terms of independent contractors, you'd want to make sure that the contract that you've got with them says that all copyright and other IP belongs to you. And also consider trademark registration, like I mentioned before. In terms of third-party IP, a lot of software products, and including games, will have third-party IP. So you've just got to make sure that you've secured the rights for the game assets that are owned by third parties. So the game assets could be anything, could be like artwork, such as textures or 3D models, the sound effects that you use, music effects, videos, or even fonts. So the very font that you use in your game, let's just say you use, I don't know, Helvetica or something, you need to buy that font and have it licensed to you, because otherwise the owner of that could make a claim against you. And we've actually worked on, last year I think, an issue where we had a wasn't a gaming company, but a software company that had used fonts which weren't licensed to them, and so the font owner got all upset, which is, you know, fair to them. They basically tried to take action against the software company. It's also important to understand how open source is used in your game, because there's a lot of open source in software, including games, and we just need to understand the limitations and the obligations of open source software. Typically when you use open source software, so that but basically this is software that's available pretty much to everyone on the basis that you use it, you can share it with others. Most open source software will have licenses, so you might have a like a license which just says, okay, you can use my open source code, that's all good. All you need to say is that you got this code from here and I am the author of that code, and it's licensed under the, say, MIT license. That's all you need to say. Other open source licenses will say you can use this code, but you then need to redistribute all of your source code for your game or software to everybody else on the basis that we're trying to share all of this code with the rest of the community. That's the sort of stuff that you don't want in your game, because that causes you a lot of problems later on when you try and sell the game, but also for the fact that if you've created this awesome game, you've got open source in there, which requires you to publish or redistribute the source code, then anyone can basically just take your game and use it, right, and commercialize it. So you don't want to do that. Generally, on a software acquisition, purchasers don't like open source in there if it's quite restrictive in terms of what I've just said before. It's okay to have stuff like the permissive stuff, which is just an attribution to who developed it, but if it just says, yep, you've got to redistribute the code, that's going to be an issue. In terms of generative AI content or output, this is such a growing area at the moment, and it's there's not a lot of law around it, but the issues will be, do you actually know that you own the output of what you have created? So you might say, create a character for me, or a logo, or a map for my game, or whatever it might be. Do you actually know where that's from and whether or not you have the rights to it? Because if you don't have the rights to it, then you could find out that you've actually infringed somebody else's intellectual property, and then they'll come knocking on your door saying, hey, we actually owned that, the character, or that image that you used, or whatever it might be, and you just don't want to deal with that, because copyright infringement claims or IP infringement claims are very expensive to try and defend. Also, can you even guarantee the accuracy or the quality of the output if you're using generative AI? The other issues will be around what happens to the information that goes into the Gen AI platform. So I know a lot of developers will be trying to test their code by putting their code into generative AI tools. But how do you know what the Gen AI platform is doing with your code? How do you know it's not being copied or used to, it'll probably be used to train the engine, right? But do you want your millions of lines of code that you've created going into a platform where they could potentially use it? And also there are issues around confidentiality and privacy issues. So if you're putting in, say, a whole lot of confidential information about your business or your game or your customers or whatever it might be into a generative AI platform, then how do you know that's not going to be used for something else? So it's really important just to have a look at the terms and conditions for the platform that you're using. Just with APIs, if you are using an API for your game, so you might be linking your game to a payment platform or a sort of security platform, as in login access, stuff like that. You want to make sure that you read those terms and conditions and understand what you can and can't do, what kind of access they have to your game, to the information, and all that sort of stuff. So an API might also be used with integration with social media platforms like X, or what was Twitter, Facebook, and all those sorts of platforms. So that's developing the game. Once you've developed the game, you want to be able to license the game, because games are licensed and are not sold to end users. Because, as I said before, you own the copyright and the intellectual property in the game. That's all yours. The legal term is to license the game to an end user. So you need to ensure that you have an appropriate end user license agreement in place, or terms of use. And these are the things that should be agreed to by the end user prior to download or installation. So I can guarantee that probably 99% of us don't even read the terms and conditions. Like me, as a lawyer, I don't read them, I just agree because I just want to play the game, right? But these things protect you as the studio or the owner of the IP if you want to enforce something against the user. So it's always good to have good terms and conditions in place. So these will cover things like how the game can be downloaded, whether or not it can be used for multiplayer use, whether or not they can be copied on multiple devices. All of that sort of stuff can be set out in your end-user license agreement. It also protects you because you'd have liability clauses in there saying that, hey, if it all turns to custard, like my multiplayer doesn't work or the game just doesn't work, if you want to sue us, then fine, but our maximum liability is whatever it is that you paid for the game, maybe like, $30 or whatever it is that you paid on Steam or whatever it is. If you don't have those types of liability clauses in there, they can basically make a claim for pretty much anything. So that's why your end-user license is really important. You should also include additional terms like if it allows other people to interact with online services or products like Facebook, you probably need to say that and how that information is being used. If it's collecting personal information about the user, you probably should have a privacy policy saying, hey, look, we're going to collect information about you, your name, your date of birth, all of that sort of stuff. You need to tell the user what you're going to do with that information. The EULA may also need to include certain terms required by the platform owner or the engine provider, such as Apple, Steam, Unity, or Unreal Engine. Those, when you're creating games, it will say, or like Apple, for example, might say, you're creating an iOS game, you need to include these terms into your end-user license agreement, basically saying that, hey, look, Apple's got nothing to do with this game, we're not liable if anything happens. Also important to understand that a lot of gamers are young children or minors. So generally here in New Zealand, in terms of contracting with minors, you can't enforce a contract against a person who is under the age of 18. Okay, so a lot of game players or gamers will be under 18. You can't enforce it against them, but the minor who is under 18 can enforce it against you. So they can enforce a contract against you. So that's something you need to understand, right? So essentially what we try and do is we get the parents or the guardians to consent or to agree to the terms on behalf of a minor. So just going through the use and monitoring of real-time chat and user-generated content. So a lot of our clients now are using tools like real-time chat and user-generated content, and they are basically monitoring and moderating what's going on within their game. But there are legal things that you need to consider to ensure that you can actually do that. So in terms of like real-time chat, so this is kind of like where you've got a game and then all of the players can basically talk to each other. A lot of game studios will now record that real-time chat and basically send it through their systems to make sure there's nothing in there which is bullying, harassment, threatening or intimidation or anything like that. But it's really important, I think, if you're going to use those sorts of tools, that you get the consent of the gamer or the user first. You need to tell them that you are using tools that record the real-time chat and that it may be monitored. So put that all in those terms and conditions. And the reason why I say that is because here in New Zealand, it's a crime in the Crimes Act to essentially eavesdrop in a conversation. And so Crimes Act, that was passed in 1961, I think, so it's old school and wouldn't have considered anything like this. So that is a real-time chat, right? And so to get around that, to make sure it's not a crime, that you're not committing a crime as a game studio, is to seek the consent of the gamer to say, we're recording this chat, and if you say anything that is bullying, harassment or whatever it might be, then we can basically stop you from using the game. In terms of user-generated content, so this is stuff which your own users or gamers can upload or put into your games, like say messaging and chat functions. your terms and conditions should have certain terms in there saying that don't include other people's so photographs or images without their consent, don't breach the rights of any third party, including any intellectual property rights, don't say anything or do anything that is bullying, harassing, annoying, threatening, or intimidates any other users, don't upload anything or provide anything that's objectionable, such as false and misleading information that's abusive, sexually related, racially, ethnically objectionable, all of those sorts of things. You'd want to cut that out. So you put it in your terms and conditions. The whole idea is that if your user does do something, you can just cut them off and stop them from using your game. And also, don't include anything that contains malicious software like viruses and ransomware and things like that. There's an act called the Harmful Digital Communications Act, which essentially prohibits the use of harmful digital communications. So essentially harassing people or bullying people through like online chat, text messages, all that sort of stuff. So a lot of the things in like the real-time chat and UGC in games could be a digital communication. So if one user makes a complaint against another user, then you as a platform owner will need to do something about that, because there are these safe harbour rules under the Harmful Digital Communications Act, which say that the game studio is not responsible provided that you take some action, right? So we'll give you a really good example. I mean, I didn't make a complaint about this under the Harmful Digital Communications Act, but I could have, is that my daughter, she's 7, and like she was on so she was using or playing Roblox. So don't judge me that she was using that. But there was a lot of chat in there which was totally unacceptable for a 7-year-old, and thankfully she wasn't reading it. I was just reading it because I was just wanting to know what she's doing. A lot of that stuff could have been a harmful digital communication, which she could have, or which we as parents could have made a complaint to Roblox to say, hey, look, this is what's happening, go and do something about it. And generally in relation to complying with the law, so almost there, my last slide, really important to comply with the laws in the place where you're marketing, selling and using your game. So here in New Zealand, for example, you've got the Fair Trading Act. You can't mislead your customers, you can't deceive your customers. So that's covered under the Fair Trading Act. You can't have unfair contract terms, so you can't have these terms which lock people into your games forever, for example. You've got the Consumer Guarantees Act. So if you've got a game on, say, that you're providing to someone and it doesn't work, then you can't say, sorry, no refunds, tough luck, because that's going to be covered by the Consumer Guarantees Act. You've got the Privacy Act, which covers off the collection of information of your gamers. Your Unsolicited Electronic Messages Act, so this is all of the information that you get from your customers, your gamers, your users. You can't all of a sudden just spam them with a whole lot of information if you want to. Gambling Act, as I mentioned earlier on, covers online gambling, because generally it's illegal unless you've got a license or a right to use it under that act. Talked about the Harmful Digital Communications Act, and then there are other things like the Land Transport Road User Rules. Basically there's a ban on using mobile devices while driving, which didn't help one of our clients who had a gaming app which required you to basically drive around and use your app, right? So you can't do that here in New Zealand. Disclose all charges clearly and in full up front. That's something that I think is quite clear, especially with in-app purchases, and if you've got a monthly rolling subscription. So that was all I had to say. Do you have any questions before we go to lunch? Cool. I think these slides will be made available so you can download them later on, or email us and we'll send you a copy.
Hi. Can we use blockchain as a trademark? Something to
sorry?
blockchain? Can we use blockchain as a trademark?
So what you need to do is probably not,
No.
because it's a like a name of it. It's the description of a technology. It's unlikely that you'll be able to kind of use it because it's quite descriptive of what it is. Kind of like saying internet or internet protocol or something like that. I doubt it very much that you'll be able to use it. You can use it. I suppose the beauty is that if it's not registered, and it's unlikely that it is that you can use it as an unregistered trademark. So you might have, blockchain as part of your branding. So you might be able to use that as an unregistered mark, but you just wouldn't be able to protect someone from using blockchain because it's such a well-known descriptive term.
And you say also that it lasts 20 years, right? Can I just like trademark my, I don't know how to say, can I, after 20 years?
Oh no, that's a patent.
That's the panel, yeah.
So your trademark, you can...
Okay, sorry.
You can trademark, yeah.
Cool.
So if you have a trademark, you can, and it's registered, and you've got it, as long as you're using it and you pay your whatever it is to renew it, you can continue to have that. It's like McDonald's, right? McDonald's will have a registered trademark over the Golden Arches. So they've had that for so long because they've registered the trademark and they've just continued to pay the registration fee. Cool. Thanks, everyone. Enjoy the rest of your day. Thanks.